Hello, dear listeners. I'm here to discuss a very important topic of the criminal law, and that is the institutional treatment for juveniles and analysis. So let's begin, friends. Since a nation's future depends upon young generation, the children deserve compassion and bestowed of the best care to protect them. A child is born innocent, and if nourished with tender care and attention, he or she will blossom with faculties, physical, mental, moral, and spiritual, into a person of stature and excellence. On the other hand, noxious surroundings, neglect of the basic needs, bad company, and other abuses and temptations would spoil the child and likely to turn him into a diligent. In light of this, the noted Nobel laureate Gabriel Mistral expressed his concern about the child care and observed, and I quote, "We are guilty of many errors and many faults, but our worst crime is abandoning the children, neglecting the foundation of life. Many of the things we need can wait. The child cannot. Right now, it is the time his bones are being formed, his blood is being made, and his senses are being developed. To him, we cannot answer tomorrow. His name is today." Friends, the children being an important asset, every effort should be made to provide them with equal opportunities and care so that they become an important asset for the society. Neglected children fall an easy prey to criminality. One of the most important objects of the Juvenile Justice Care and Protection Act 2015 is to provide a family environment to the child for his or her holistic development. Where it is not possible to provide for such an environment, it becomes mandatory to see that the rehabilitation of the child is done. The basic aim is to reintegrate him or her into the mainstream of the society. We need to realize the importance of institutional care towards the rehabilitation of children. But it is important to note that the principle of institutionalization should be a measure of last resort, which means that the placing of a child in institutional care shall be a step taken as a last resort after making due inquiry. Also, they should only be used if no other option is available to correct the child or rehabilitate the child. Institutional form of treatment is necessary for the accommodation, treatment, and training of children who have been apprehended under the provisions of the Act. Each institution should have a well-regulated daily routine for the children, which should provide for regulated, disciplined life, physical exercise, educational classes, vocational training, recreation, and cultural activities. It is necessary that the children kept in these institutes should be classified on the basis of their age, physical and mental health, length of the commitment, and character. The process of rehabilitation starts as soon as the child is admitted into the institution and continues till he is rehabilitated and adjusted in the society. The present state is called a welfare state. That means that an obligation is put on the state to look after the welfare of its people. The same principle holds true for a juvenile as well, wherein the responsibility and the obligation is put on the state to look after the child care, protection, and development. Not just this, but it is important that all the needs of the children should be fulfilled by the state. Through the social welfare programs under the Act, the onus is put on the state to take the responsibility of ensuring developmental activities of the children, especially coming under the ambit of the Act. Section 2, subclause 14 define a child in need of care and protection, and The definition is very elaborate as it includes a child who is neglected, abused, or whom avenues for physical, moral, or psychological development are denied. The overall development of such a child does not take place. The next thing that we would be talking about are the child welfare committees. Friends, for the purposes of dealing with the children in need of care and protection, the state government has established child welfare committees. The committee shall have a chairperson and 4 members. The Child Welfare Committee has the powers of a judicial magistrate first class or metropolitan magistrate. It is the duty of the committee to reach out to the children in need of care and protection and to make visits to the child care institutions. Further, it is the duty of the committee to ensure that no person who is not connected with the case or in whose presence the child does not feel comfortable is removed from the room where the proceedings are being held. One of the important powers conferred on the Child Welfare Committee is that it would have the final authority to dispose of cases pertaining to the care, protection, treatment, development, and rehabilitation of the children. They are empowered to provide for the basic needs of the children as provided under Section 20 of the Act. A child in need of care and protection shall be produced before the Child Welfare Committee within 24 hours of his apprehension, and the committee is empowered to send the child to a children's home or a fit facility or a fit person during the time the inquiry is pending. The next topic that we discuss are the special homes. Special homes are the institutions for the children in conflict with law. The children who are found guilty by the Juvenile Justice Board are placed in special homes. The definition of a special home is given under Section 2, Subclause 56 of the Juvenile Justice Care and Protection Act 2015. Further, Section 48 of the Act talks about the establishment of these homes. This section puts an obligation on the state to establish and maintain either on its own or in collaboration with a governmental organization or a non-governmental organization for one or more districts. These homes are for the reception, rehabilitation, and reintegration of children. These homes help the child to mobilize its inner strength and capabilities. Open shelters. Section 2, Subclause 41 defines open shelter as any place established by the state government by itself or in collaboration with a non-governmental organization for a specific purpose. Further, Section 43 explains the concept of open shelters and states that these institutions shall function as community-based facility for children who require care and protection for a very short period of time, including residential support with an objective of protecting them from abuse and making them stay away from a life of abuse and neglect. Further, Rule 22 of the Juvenile Justice Care and Protection Model Rules 2016 talk about the open shelters. These shelters provide both daycare and night care facilities for children in need of care and protection, including the food, washing facilities, and toilets. The number of children who can be accommodated in these shelters is between 25 to 50. No child should be refused admission to the shelter. The next topic that we discuss today, friends, is a place of safety, wherein Section 2, Subclause 46 of the Act defines a place of safety, which categorically states that it should not be a lockup or a jail where the child in conflict of law would be sent to. The only justification for this is that we need to emphasize on the best interest of the child, and that would not be served if we send him to the jail. A child who is found to be in conflict with law shall be kept in a place of safety till he is 21 years of age. Further, it is important to mention that there has to be a proper segregation of the two kinds of children housed in a place of safety, and those are children against whom inquiry is pending and children against whom the inquiry has ended and they have found to be in conflict with law. Now let us discuss the next topic, and that is a fit facility. Another institution that needs a mention to deal with child in conflict with law is a fit facility as defined under Section 2, Subclause 27 of the Act. This facility is established to look after children for a short duration of time and take the responsibility of the child. Other than the observation homes, special homes, place of safety, or children homes, fit facility is established. Under Section 51 of the Act, it is stated that the Juvenile Justice Board or the Child Welfare Committee may recognize any facility as a fit facility established by the governmental or the non-governmental organization for the temporary reception of the child. The object of this facility is to study and diagnose the juvenile's current problem and to enable the authorities to come to an intelligent and well-considered decision in respect of the juvenile's case on the basis of a report on psychological, sociological, psychiatric and environmental factors. The next thing that we are going to discuss is a definition of a fit person. Section 2, Subclause 27 of the Juvenile Justice Act defines what a fit person is. It is a person who is prepared to take the responsibility of the child for specific purpose and is recognized by the Juvenile Justice Board or Child Welfare Committee. Rule 28 of the Juvenile Justice Rules 2016 lays down elaborate guidelines for the recognition and incidental issues pertaining to the fit person. The Juvenile Justice Board or the Child Welfare Committee shall recognize a panel of persons as fit persons based on their credentials, respectability, expertise, professional qualifications, experience of dealing with the children, and their willingness to receive the child. What is the time duration of stay of the juvenile with the fit person shall be decided on case-to-case basis in consultation with the fit person. Now let us talk about a very interesting topic, again dealing with the juvenile justice, and that is rehabilitation and social integration of a juvenile. Now one of the most important things for both the child in conflict with law and child in need of care and protection is rehabilitation and helping them to adjust in the society. But it is further important to mention that the attitude should always be child friendly. In any institutional program, the period immediately following the admission of a child is of fundamental importance because it is the time he receives the first impression of the institutional life and comes into contact with people of institution. It is during this period that a diagnostic procedures essential to the planning of the treatment and training program have to be put into operation. It is important to assess the juvenile's strength and interest and identify community resources to build on those strengths in a way that demonstrates competency. It is important to engage the juvenile in activities that provide necessary support for the successful completion. Because these children face some problem while growing up, and the best way to handle their problem is through institutions established under the Act. They help in providing institutional programs for improving the care, welfare, training, and treatment services and maintaining minimum and uniform standards necessary for the development of the child. These institutional programs are necessary to assist them to assume socially constructive and productive roles in the society. Children also possess rights and they should be respected. This respect of the rights should reflect in the programs adopted by these institutions talking about the rehabilitation of the children. It is important that the rehabilitation plan for children in need of care and protection should be aimed at providing family-based care for the purpose of restoration of the child to the society. It is important that while importance is given to the interest of the child, some important facilities have to be provided by institutions mentioned under Section 53 of the Juvenile Justice Care and Protection Act 2015. This is also mentioned under Chapter 6 of the Juvenile Justice Care and Protection Model Rules 2016. Dear friends, it is important that all the institutions established under the Juvenile Justice Care and Protection Act 2015 ensure that best facilities should be provided for the care, protection, rehabilitation, and reintegration of the child. Some of the services made available to the children are: number 1, providing proper facilities like food, shelter, clothing, and medical attention. Further, the Act also emphasizes on paying special attention to specially abled people and provide them with hearing aids, wheelchair, braille kits for special needs of the children. Point number 2, providing education to the children. It can be said that the children who are committed to the institutional care are mostly those whose formal education has been inadequate to develop their talents and potentialities fully. Number 3, further, it is important to provide vocational training to the children in these institutions. This would help them earn their living, and a suitable vocational training program should be made according to their interests and aptitude. Point number 4, providing the facilities of legal aid. Point number 5, for healthy all-round development of the child, the institutional program should include regular physical exercise and recreational facilities. Point number 6, for having the identity of the child who does not have a birth registration should be provided with the registration of the birth and having a birth certificate. Point number 7, further, it is important to note that all the children staying in these children institutions, a diet plan for such children shall be prepared in consultation with the nutrition experts so that the diet becomes balanced, nutritious, wholesome, and varied. This finds a place under Rule number 33 of the Juvenile Justice Care and Protection Model Rules 2016. The next topic that we discuss is right to privacy and juvenile justice system. There is a direct connection between the juvenile justice system and the right to privacy. Section 99 of the Juvenile Justice Care and Protection Act 2015 categorically states that all reports dealing with juveniles mentioned under the Act are to be treated as confidential. The basic reason for this is to avoid any stigma on the juvenile. Rule 8.1 of the United Nations Standard Minimum Rules for the Administration of Juvenile Justice provides that, and I quote, "The juvenile's right to privacy shall be respected at all stages in order to avoid harm being caused to her or him by undue publicity or by the process of labeling," and I unquote. In addition to this, Rule 8.2 further states, and I quote, "In principle, no information that may lead to the identification of the juvenile offender shall be published," and I unquote. The only two conditions where the information may be shared are, number one, where the case of the juvenile is transferred from one committee to another committee, and number two, the report may also be shared with the parent or the guardian of the juvenile. Now, coming to the conclusion of this topic, dear friends, institutional form of treatment is necessary for the accommodation, treatment and training of children who have been apprehended under the provisions of the Act. Each institution should have a well-regulated daily routine for the children, which should provide for regulated, disciplined life, physical exercise, educational classes, vocational training, recreation, and cultural activities. It is necessary that the children kept in these institutes should be classified on the basis of their age, physical and mental health, length of the commitment, and character. The process of rehabilitation starts as soon as the child is admitted into the institution and continues till he is rehabilitated and adjusted in the society. The present state is called a welfare state. That means that an obligation is put on the state to look after the welfare of its people. The same principle holds true for a juvenile as well, wherein the responsibility and the obligation is put on the state to look after the child care, protection and development. Not just this, but it is important that all the needs of the children should be fulfilled by the state. Through the social welfare programs under the Act, the onus is put on the state to take the responsibility of ensuring developmental activities of the children, especially coming under the ambit of the Act. It is important to mention here that the Juvenile Justice Care and Protection Act 2015 is a comprehensive legislation by putting an emphasis on the mental and the physical health and well-being of the juvenile. Further, it is important that any juvenile who is sent to any of these institutions established under the Act should be sent to an institution of a familiar environment. The child would be treated, trained and brought up in a familiar environment, which means that the environment should be well-acquainted environment. This would lead to the overall growth and the development of the child, and the framers of the Act have kept that in mind. A continuing public authority is needed with responsibility for the treatment programs both in the community and in juvenile institutions. Treatment programs for juveniles with psychological or social care are essential in the civil society. To improve the juvenile courts, it is important to strengthen its link with the rest of the system, especially with those agencies that sponsor treatment programs. With this, I come to the end of this lecture and hope to see you soon in another session with an enthralling lecture. Thank you so much, everyone.